recording. Okay, so everyone, we're gonna bounce around in our textbooks, or crash course book. I want to talk a little bit about some due process stuff, and then we did 1 through 6, right? Yeah, because we were at Reynolds. We're at First Amendment free exercise clause. We're going to skip that, and we're going to jump over to where it says Part 6, Case 15, 16, 17, and 18. Okay? Again, when we come to these court cases, what do we need to know? The impact and the theme. Okay? What's the case about? I think this just came to me. It's almost like the topic of the case. So, like, for example, if I said, Engel v. Vital, the theme of that would be the Establishment Clause and Engel v. Vital, school prayer, which you better all start doing right now. That's a joke, get it? Prayer.
Yeah,
oh, God. No, it's not, but I was trying to, you should know Engel v. Vital. We talked about it. We have to be able to recall this information. Have to. If you have to take 5 minutes a week and go through the cases that we've already discussed so you understand them and you can recall them, that's what you have to do. How bad do you want it? How bad do you want to take all the work, all the sweat, maybe even some tears? How much do you want that to be for nothing? Or do you want it to be for something? So you got to go back and look. So Engel v. Vital, that theme would be the Establishment Clause, school prayer, and the impact was that it pretty much said school prayer is not allowed because it's a violation of the Establishment Clause. All right, so let's hop back over to Weeks. Okay, Weeks v. United States, due process clause. The due process. No, due process includes so many different things. Rights of a defendant, right to an attorney, right to know what you're accused of, rights to a speedy and public trial. That's all due process, the process of going through the legal system. Now, Weeks v. United States dealt specifically with what? So it dealt with due process, and what's the other part of the theme? Sir?
Illegal searching.
Close. You're not wrong, but it's not what I want you to remember. Man. The exclusionary rule. Now we need to understand what the exclusionary rule is, because if we said exclusionary rule in a FRQ, what is the next sentence? We need to explain in one sentence what the exclusionary rule is. Anybody have and use your critical thinking skills about what it means, and it's in the book too. So.
Evidence that is obtained illegally can't be used in court.
Exactly, that's what the exclusionary rule is. If I illegally search Marin's purse, let's say public school student, bad example. Let's say I'm a police officer walking down the street and I just say, give me your purse, I'm going to search it. And I find, an unregistered firearm. That's an illegal search, folks. I had no probable cause to search her. I had no reasonable suspicion. I had nothing. It was just searching her. The court would not be allowed under the exclusionary rule to use that piece of evidence against her. It'd be thrown out completely. Probably wouldn't even make it to court. It'd be thrown out so fast. That's what the exclusionary rule is, okay? It's a Latin term, if you could ask your parents. It's like fruit of the poisonous tree. Your action is the poison. You can't get a piece of fruit from the poisonous tree. Your poisonous actions cannot get something good. It's a Latin term. I forget it now. You don't have to know the Latin term. You don't have to know this Latin term. But it's something I learned back in college that I didn't learn very well, apparently. But it's the fruit of the poisonous tree, and it deals with the exclusionary rule. Okay? So that's a right of a defendant. Okay, that's a right of a defendant. If Rahel, we searched something illegally, and we we find evidence that she committed a crime. Doesn't matter. If I search her legally, under Weeks v. United States, that evidence cannot be used because it will be excluded from the court case. So the theme is that it's a due process theme or due process case, and it deals with the exclusionary rule, and it established that evidence that is collected illegally cannot be used in court. That's how simple it is. Now, I wish there was a clever way I could tell you to remember Weeks v. United States, but you just got to learn it. Just got to learn it, okay? All right, let's go on to Matt v. Ohio, okay? Matt v. Ohio. Very similar to Weeks, but it has another theme. What's the other theme we could add to Matt v. Ohio, Alex? Selective incorporation. So it's a due process, selective incorporation case that deals with the exclusionary rule. We need to explain the exclusionary rule, but it extended it to states. That's it. Remember Gideon v. Wainwright? Extending the right to counsel to state cases? This extended the exclusionary rule to state cases. And look at the time difference there, folks. That's a long time. What is that, 45 years, 46 years, 47 years? I can't do math, apparently. I mean, that's crazy. So during those time periods, if you were committed a crime in the state of Florida and they collected evidence incorrectly or illegally, doesn't matter. Doesn't matter. Because Weeks v. United States does not apply to state law if it happened before 61. Imagine how frustrating that would be. That'd be, well, hopefully you wouldn't have anything illegal on your persons or in your possession, but again, very, very upsetting. One that we've already talked about a little bit, Gideon v. Wainwright. I'm flipping the page if you have a page. Gideon v. Wainwright, you should know, again, rights of those defendants, okay? Right to an attorney. Again, you see what I'm saying? Like the key words that we're talking about. We talked a little bit yesterday about using vocab terms when we can. Exclusionary word's a vocab term, but then we need to explain it. Okay? We need to explain it. Gideon v. Wainwright, rule the Sixth Amendment. You need to know Sixth Amendment. Again, we're going to pick up with the Eighth Amendment on Monday again. We're going to get back into that. But you need to know your amendments. Okay? Extending the Sixth Amendment right to counsel applies those accused of major crimes under state law, okay? Or just crimes under state law. You don't have to worry about the major part. So the theme is due process. The other part of the theme is selective incorporation. And the other theme is right to counsel. So we got three themes there, okay? And then the impact was that it extended a person's right to counsel to state law. Okay? Now, let's talk about a little about selective incorporation real quick. What allowed selective incorporation to exist? More specifically, no, not due process. Equal protection clause. The equal protection clause. Remember I used the door example? I don't know if that's really even a good example. I don't know if it helps you guys. But the equal protection clause of the 14th Amendment allowed that door to exist. What opened that door? It's a court case. I'm trying to find the number for you. We haven't talked about this court case, but I have brought it up. In New York, yeah. Gitlow v. New York. So Gitlow opened the door. And then each time I walk through it, it is the individual cases of selective incorporation. Gideon v. Wainwright. Weeks v. Ohio. Okay? Those are constantly going through the door. Okay? I don't know if that's a good example or a good analogy that you can remember it, If you can think of a better one, I would gladly use it. But again, what allowed selective incorporation to exist is equal protection clause. What opened the door? Gitlow v. New York. And then the individual cases that dealt with selective incorporation established selective incorporation selectively. That's the key. Selective incorporation is not a broad idea. It has to be very selectively established, like the right to counsel, like the exclusionary rule. Do you see what I mean by selectively? That's very, very important. It's just not the incorporation doctrine. It's the selectively incorporation doctrine. Okay? Doctrine, clause, same thing. Okay? All right. Say again, Jimmy. I'm so sorry. What do you mean after? Well, due process is what we're talking about today. It's like the idea of your right to counsel. That's found within due process. That make sense? Yes, there's multiple parts of the 14th Amendment. I'm sorry if that confused you. Yeah, there's multiple parts of the 14th Amendment. I mean, if you look at the 14th Amendment, it doesn't come out and say selective incorporation, equal protection. Well, it says equal protection under the law. But through the interpretation of the 14th Amendment, you established a due process clause, you established selective incorporation, you establish the equal protection clause. Does that make sense? Like it has multiple parts. You guys want to look at the 14th Amendment real quick so we can wrap our brains around it? I don't know where it is in this book. I'm so not used to having a paper book. All right, to heck with it. One second. My little pocket constitution. I can't find it in here. This is really sweet. Not the 18th. There it is. Okay, the 14th Amendment. Now, it's got some stuff in it. It's a little bit longer. I'll briefly read it as fast as I can. All persons born or naturalized in the United States, subject to jurisdiction thereof, are citizens of the United States and state wherein no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor should any state deprive the liberty without due process or deny within its jurisdiction equal protection of the laws. That section 1 of the 14th Amendment established that idea of equal protection. Everyone is equally protected under the law. Everyone is afforded due process. Now, you're probably thinking, where else is due process mentioned? Looking at it right now. I'll just tell you. Amendment 5. But due process is only extended to who in Amendment 5? Who? Nope. Well, yes. You're not wrong. Yes, just the federal government. But to criminal defendants. To people accused of crimes. Not to regular citizens. Do you see the difference there? Like, you have to be first accused of a crime, so that's why they have... That's where you get the equal protection part. Like, no matter who you are, if you're a citizen of this country, technically, even if you're not a citizen of this country, you are afforded protection. Okay? Yes.
Was it right away that it was also like non-citizens that are in the U.S. or was that like after?
You have to realize the evolution of our court system is very dynamic, and it's not just a law thing; it's a cultural thing. It's a cultural thing, meaning back during the 40s and 50s, you wouldn't want to be here, Rahel.
That's why I'm asking. That's
Yeah, you weren't. Yeah.
So that's why.
And nowadays, you would be treated with full rights and all that kind of stuff. But we're still denying some people rights. I mean, if you look at Guantanamo Bay with those captives there, I mean, regardless, you think they should be there or not be there, it's your opinion. But they're not being afforded due process. It took a while for them. So that's kind of a cultural kind of American perception thing. But during that time, you would argue that not everybody was afforded that. I mean, you look at the internment camps. Look at the internment camps. You guys all know what the internment camps were. If you don't be ashamed. You should have learned it in U.S. history. We rounded up Japanese Americans. or anybody that looked Japanese. Chinese got stuck in there too. Sorry, guys. And we threw them in camps. They were internment camps, not concentration camps, though they were kind of concentration camps. They were fed, they had a place to sleep, but they were like little prison camps. Because we were so concerned about, well, what we told everybody is we were concerned about their safety. But what it really was is we didn't trust them. And these were American citizens too. And there was actually a court case, Korematsu v. the United States, and they ruled that the internment camps were constitutional. But everybody looks at that judgment as completely false. Like, they weren't constitutional. But again, even though they were American citizens, they weren't afforded all the rights. Just be glad you're here now. Being German during the 40s, not so good. Not so good. All right, continuing on. Yeah, we don't need to look at section 2, 3. Yeah, we don't need to look at the rest of that. But section 1's the big one of the 14th Amendment. So through that interpretation, specifically of the section 1 of the 14th Amendment, we get the Equal Protection Clause. We get the Due Process Clause. We get those types of things. But due process is what we're talking about today. You know, and what's the last due process one? And that'd be the last court case that we're talking about is Miranda v. Arizona. Miranda v. Arizona is the easiest one to remember. Who doesn't remember? Well, hopefully no one's been read their Miranda rights. No one's been Mirandaized yet, right? I hope not. No one would admit it if you were. But yes, hopefully no one has been Mirandaized. And that means, what, you don't know Miranda? Oh, I'm so sorry. Anybody know the Miranda rights? You can come on in. Diana, get your butt in here. Take a seat.
The right to attorney, whatever you say, can and will be
Used against you in the court of law.
Oh.
Yeah. Folks, I'm going to be honest with you. It is not as theatrical as it done on the TV shows. When you get Mirandaized, you sign a piece of paper. And you get Mirandaized every time you're questioned. Like, it's not like so, like, when you get led away in your handcuffs, you're not getting Mirandaized. No. It's a very formal thing. And they show you a piece of paper, and you sign that you've been Mirandaized.
Why is it called that?
Because of Miranda v. Arizona.
Oh.
Miranda v. Arizona ruled that the police must inform criminal suspects of their constitutional rights before question. Rights of the accused require police to read the Miranda rules to criminal suspects. They not only read them to them, but they give them a piece of paper and they have them sign. Like it's not like the TV shows, folks. I'm so sorry to crush your bubble.
Do they read it as well?
Oh yeah. They don't mess around because if you don't Mirandaize something, the information collected during that hearing would be unconstitutional and excluded from. Could you imagine if a murderer admitted to a murder and you didn't Mirandaize that person?
I was just wondering, like, if you go now to police and you're like, oh, I killed this person, then, like, they can't use that against you.
Not technically. Well, that would be different because you're openly admitting it in a public area. You're not under questioning. Again, we're splitting some hairs here, Rahel. Like that, if you like that kind of stuff, go become a lawyer. Because that is we don't get that detailed. We don't get that detailed. Unfortunately, we can't. But Miranda v. Arizona, the theme is due process. Okay. What's the other theme of it, you think? What's it about? What's the topic? Rights of the accused, civilian rights during questioning, and then the impact was police must inform suspects of their rights. That's it. That's the impact. Pretty big impact. Because Miranda, I think, was a murderer. And he wasn't aware of his rights. I don't know if I think so. It's a last name. It's last name. Like, it wouldn't be like Rahel v. the United States. It'd be Hirsch v. the United States. Don't sue the United States. Don't do that. Okay. When we get to the FRQ today, I demand to see great strategy. I demand that you do well. Because I know you're going to. I'm glad we could go over these court cases. Very important stuff there. What other questions you have for me? Anything about the strategy? Anything about, the media stuff? Questions, ma'am.
Can you explain what we're supposed to do for
Define has multiple parts. So when you look, this is a perfect FRQ for forcing you to think. Forcing you to think. When you see define and you'll have this term, you need to think, okay, it's going to have multiple parts. I need to hit multiple ideas within this. Now, the ideas aren't different. It's not like it has multiple definitions, but the definition itself has many pieces to it. Not many as in 10, but more than one or two, okay? So I want you to slow yourself down today. It is not a long FRQ. It's not like a 4-parter, okay? Slow today. I think I might force you to think for 3 minutes today. So no pencils for 3 minutes. Ma'am.
So do we have to do like A, B, C, D with the separate parts?
Thank you for thinking that way, but no, don't do that. Don't do that. The reader is expected to find those parts. Okay. Very good question, Bo, though. Very good question. I think you're going to do great today. Then you do great tomorrow. And then you'll have a 2.5-day weekend. Yeah. I got one parent counselor. Please have your parents come see me. I get lonely. Seriously, just have them come talk to me. Even if you have an A or B in this class, come talk to me. I get lonely. I have one conference at 12:45. I probably turn off the recording now.